Thanks, newly minted Dean. 2.5 hours. That's great. Thanks, Beth. And it's good to be here this afternoon to the students here at the Faculty of Law, U of S. We've got about 45 minutes. I'm not going to keep you longer than about 2 minutes to 1. So last time I spoke, I know I kept students a little long, and I got to get my next class, So we'll probably be wrapping up about 2 minutes to 1. The last time I did this presentation was in March of 2014. And now we're into October of 2014. And there's certain things that have happened in the last 6-7 months. So my presentation is going to have a new twist to it. In light of, there's 4 things that really happened that are very impactful when you start talking about inherent rights, treaty rights, indigenous peoples' right to self-determination, or even Aboriginal rights in title. And one of the big things, of course, is the William case, the Chilcotin case that came down. Supreme Court of Canada, 8-0. Fantastic. That was good. And, of course, the Kuwaitan case came down as well a couple of weeks later. And as well, the United Nations Declaration on the Rights of Indigenous Peoples, and an outcome document that was supported by every country in the world, was also supported by the United Nations a few weeks ago, but one country put a caveat on it. And I'll let you all try to guess what country put the caveat on that UN declaration. It was Canada. And so there was 3 important things that happened that had an impact on our rights, fundamental human rights as well. Those 3 things. The other one that had an impact for me in a big way was the resignation of National Chief Sean Atleo in May. So because of that, I'm also campaigning now for National Chief coming up in December. So there's 4 things that have happened in the last 6-7 months that have had huge impacts, not only nationally but internationally. The presentation, Saskatchewan First Nations and the Province's Resource Future, the Path to Economic Certainty. And with this whole position, I'm only going to use about 6 or 7 slides. And one of the most important slides for me that I go back to when we start talking about inherent rights, treaty rights, Aboriginal rights, and I go with this timeline here. And for me, this is very important for all of us to understand, and any opportunity I can to come speak to people, whether it be high school students, university students, chambers of commerce, presidents of corporate Canada, policymakers, I always try to take that opportunity because I'm trying to show people and demonstrate to people that when we get up and say, hey, we only shared this much, as Indigenous peoples, that when we start talking about concepts like resource revenue sharing or the right to self-determination, that there's a very strong basis in history, there's a very strong basis in legal facts that I want people to get. That it's just not Chief Bellegarde spouting off at the mouth because that's what he's elected to do. That these things are founded in history and fact and a very strong basis. So if you're going to become lawyers, you're going to become judges, policymakers, I want you to have a good background and good understanding of it. And that's why I'm here, to kind of show you the other side, or, that's what they're talking about. I want some hmms to go off, hopefully. So, the big thing for me, and I always go back to the Doctrine of Discovery. And why is that important for us? That's very important for us to look at. Because how else did countries of the world go out and gain title to the land and resources, right? In that Doctrine of Discovery, you all know, as you go to a country, you plant a flag, boom, it's now ours. I always joke, and I said this last time too, I was in Great Britain, England, about last year to celebrate the 250-year anniversary of the Royal Proclamation of 1763. So I brought our Treaty 4 flag along, and I planted it right in front of the palace. So it's now our land, It's now our territory. How do you like that, Great Britain? So the Doctrine of Discovery, it's important because now people are starting to view and starting to question the legitimacy. They're starting to look at it and say, is that really right? Is that really fair? Is that really just? So even in the United Nations, the Holy See is already starting to look at the Doctrine of Discovery as a racist doctrine. And it is. That's my perspective, my view, but that's where I start from. Because how else can countries still gain title to land if it's really, when the indigenous peoples were there for thousands and thousands of years? So that's starting to be questioned, not only domestically, but in international forums as well. And that's why it's vital for us as indigenous peoples to keep participating and keep attending within the United Nations forums. The other one, terra nullius, land belonging to no people. The Malbo decision, but the concept of terra nullius, vacant land. Well, really was it vacant? Really was it vacant? The concept of terra nullius. When indigenous peoples, again, were living from the land, were of the land, and the water as well. So those concepts are really starting to be challenged now. And to me, I think that's a good thing. Because you have a dialogue, you debate, you're growing your mind, you're growing your thoughts, you're growing your assessments and your views of the world. You know, because even when you apply, and you look at in Canada you've got, well, let's look at Saskatchewan first. You've got 74 First Nations. Okay? You've got 9 different tribes, or I'll say 6 different nations, if you will. But 74 First Nations. You know, all the reserves in Saskatchewan, 74 reserves, 74 chiefs, 74 First Nations. But you have the Woodland Cree, the Plains Cree, the Swampy Cree. You also have Chianishna, Beck, the Soto Nakaway peoples. You also have the Dene Sontlene in the north, the far north, the Dene people. You also have the Dakota, Lakota, Nakota peoples as well. Different tribes, different nations of people. We're about 14% of the population in Saskatchewan. You've got Treaty 4, Treaty 5, Treaty 6, Treaty 8, Treaty 10. Okay? The number treaties. So indigenous peoples, we're about 14% of the population. We're on a very small land base. 50% of our population reside off reserves. So the issue of portability of rights is always a big thing for us. And then in Canada, you've got 633 First Nations, 633 chiefs. 203 in British Columbia, 47 in Alberta, 74 in Saskatchewan, 66 in Manitoba, 134 in Ontario, 45 in Quebec, 35 on the East Coast. You got 26 in NWT and 14 in the Yukon. I know my numbers because I'm running for national chief, man. Those 633 votes. It's what it is. And only the chiefs get to vote for the national chief every 3 years. You've got treaties right across Canada, right from the East Coast to the West Coast. You have the numbered treaties 1 to 11. You have the pre-Confederation treaties, the Robinson-Huron treaties, the Robinson-Superior treaties, the Turo-Wampum Treaty with the Wampum, the Haudenosaunee, the Mohawk peoples. You've got over 58 different nations in Canada. 58 different indigenous peoples, different tribes, right across this country. Right up to the West Coast, the 203 First Nations, you've got about 40 different nations in BC. You've got modern-day treaties in British Columbia. You've got the Douglas treaties on the island. You know, so right across this land. And out of all those 633 First Nations, those 58 different nations, if you will, why I take the time to explain this, the inherent right to self-determination. If we're indigenous peoples, do we have our own land? Very small basis, but yeah, we have our own land. Do we have our own laws? Yes, we do have our own indigenous laws. Do we have our own identifiable forms of population, our people? Yes, we do. Identifiable forms of government? Yes, we do. Kind of there, even in spite of the Indian Act. And then our own identifiable languages. 5 very important elements to qualify an international law for the inherent right to self-determination. And if you have the inherent right to self-determination as indigenous peoples, you have the ability to enter into a nation-to-nation relationship with the Crown via the treaty-making process. Very important. Very important to remember that. So now, back to this timeline, and I'm going to come back to, in Saskatchewan, why it's important. And I'm going to end up talking about these things, yes. The NRTA, yes. The Natural Resources Transfer Agreement. But leaving it off with the Chilcotin and the Williams case. Okay? And then moving forward, what do we need to do together? So, very important, those 2 first bullets. The third one, the 1763 Royal Proclamation. Very important. It's the first time the Crown recognized Indians' title to land and territory, and that there was a process, again, via the Crown. You always hear the honor of the Crown, the honor and integrity of the Crown. It's the Crown. Is the Crown divisible? Federal Crown, Imperial Crown, Provincial Crown? It's the Crown. Right? The Royal Proclamation, very, very important document. And so last year was 250 years. 250-year anniversary of the Royal Proclamation of 1763 on October 7th. The King declared it. Back in that time, October 7th. And so we marked it by going to England. So our relationship with the Crown as Indigenous peoples is very key, very fundamental. We keep it not in reverence, but we respect it because of our nation-to-nation relationship with the Crown and right of Great Britain. Okay? But that's how it happened. So the Royal Proclamation is very important. First time a foreign government, if you will, a foreign nation, recognized inherent rights, Indigenous people's title to land and territory. And there was only a simple process to gain access for the Crown to gain title. But it was recognition of First Nations rights and title to land and territory. Why we put the Royal Proclamation there? Because it also forms appendices to Canada's Constitution. BNA Act, 1867, British North America Act, Section 9124. The federal government is responsible for Indians and Indian lands. It doesn't say Indians on Indian lands. It says Indians and Indian lands. So why is that important? Further recognition. Further recognition that we're just not here in Canada as Indians. We also have lands. Section 9124. We also talk about why, as treaty Indians or Indian people, we're a federal government responsibility. There's a federal fiduciary trust obligation to Indians. It's because of Section 9124. The federal government's responsible for Indians and Indian lands. Another key point. Then we go to this 1870 Imperial Order in Council. Why I always refer to that one? Because, again, the timeline. And I'll just quickly go to number 8. Oh, this one. The Order in Council is important. Because when lands are taken up in Canada, the Indians or the Indigenous peoples, it says Aborigines. But it basically referring to us beautiful brown-skinned people here living on Turtle Island. You know, whether we're Aborigines or Indigenous peoples or Nehiyawak peoples or the Haudenosaunee peoples, we're supposed to be compensated fairly. So when lands are taken up for settlement, it says there, the claims of the Indian tribes to compensation for lands required for the purposes of settlement will be considered and settled in conformity with the equitable principles which have uniformly governed the British Crown in its dealing with the Aborigines. So I always ask my fellow Indigenous brothers, have you been compensated lately for all the land we're sharing with our brothers and sisters in Canada? There's a joke, you guys. Come on. It hasn't happened. Right? Because, again, 633 First Nations, we're 4% of the population. We're on less than, 1% of land? What's exactly? Like, we occupy very little land now as Indigenous peoples. So I always say this, think of all the land we're sharing. Think of all the GDP that's generated from the land and resource wealth, gross domestic product, that if it wasn't for the treaty relationship, with the Crown, this country would not have been opened up for settlement. So, when you start seeing that there's 10,000 First Nation students on the wait list to go to post-secondary education, the cap should be gone. And then I always said this, even a few months back, a few weeks ago, we were in this big forum, and Seamus O'Regan, he's running for the Liberals now. Remember Seamus, Canada AM? He's on the guy on Canada AM. You guys got to know Seamus. Come on. Well, Seamus was in this group, this roundtable, talking about treaties and inherent rights. And it was a very safe environment. So he says, well, Perry, I'm going to ask you this. I used to always get upset when I was in school and university, and then I'd go to university with Indian people, students, and then I used to always get upset when they used to get everything for free. And I said, Seamus, I want to talk to you. Come on, let's go have a coffee. And so I had to go through the whole idea about inherent rights and treaty rights and explaining the spirit and intent of education, the spirit and intent of we're supposed to share all of the... And I opened his eyes that look at all the land we're sharing as Indigenous people. Look at all the billions upon billions that are generated from the land and resource wealth. And you still want to say we get things for free? So after the coffee, he says, okay, I got it. I won't say that anymore. So it took about maybe about 40-minute conversation, Val, I think. About that long. But it's that education awareness. Because even when I went to University of Regina, with my study group, my white buddies and Chinese buddies, there wasn't a lot of Indians there. I'd have to educate. Because there's still that perception that we can still get everything for free. So there's a lot of dialogue we need to go through. There's a lot of discussing, talking we need to go through. So it goes back to this 1870 Order in Council. It's part of that time frame. Compensation when lands are taken up for settlement. I want to go back. Oh, there we go. So that's the 1870 Order in Council. Then I go to Treaty 4, depth of a plow. Why I put that depth of a plow there, it just tweaks my memory. Because I didn't learn this in school. What I'm about to share with you are oral traditions, oral teachings, oral understandings. Because after I got out of university in 84, 85, I got into politics right away. I didn't get into business. I got into politics, First Nations politics. And I started spending a lot of time with our elders and our spiritual people. And every time I'd go visit them, I'd have bannock and tea and everything else visiting, And then they'd start schooling me. They'd start teaching me. And I was visiting late Deaf Henry Kay from Kawakatus and old Moted, old Whitehead from Yellowquill, two old elders in our Treaty 4 territory. They were sitting around the kitchen table and they're speaking Soto and speaking Cree, and because I'm not fluent, they'd include me in some of their conversations, and they'd say, no shum. What are you doing? That big government had no right to give to that little government all these resources. They talk about the land, the water. Even the ones beneath this, we'd share this much. We'd share with them. That's all Kawakatus agreed to. Little Black Bear would share this much. They want to farm. Magiwai Uma, nothing underneath. The depth of a plow. Only the depth of a plow to share because they wanted to farm. So when I do this, and I do this a lot, I do treaty presentations. It's not me. Those are only two elders. But I've talked to many elders in Treaty 1, Treaty 2, Treaty 3, Treaty 4, Treaty 7 in Alberta, Treaty 8 in Northern Alberta, Northern BC. They're all consistent. They're all consistent in their teachings. That in that treaty, when you see the cede, surrender, and relinquish clause, you don't understand cede, surrender, relinquish, but sharing, how we're supposed to live in peace and harmony and coexist and mutually benefit from the land and resource wealth, sharing. Concepts our people could understand. But in the treaty itself, depth of a plow we'll share with our white brothers and sisters. So they could farm. So sharing. Ceding, surrendering, relinquishing. Legal terms. There's a growing school of thought now. Does that mean if one party to a treaty didn't really understand it, is it legal and binding? Makes you go, Maybe that's the next dialogue we got to get into. But in exchange for sharing, in the numbered treaties, 75,000 square miles in Treaty 4, 125,000 square miles in Treaty 6. In exchange for sharing that land, our reserves were set aside for us. We have our annuities. Chiefs get $25. Headmen $15 a year. Every man, Indian woman, and child $5 a year. So for maintaining the good peace and order in Canada, I get $5 as a treaty Indian, right? Treaty Day. The Crown comes out, Indian Affairs bureaucrats come out. RCMP is there in the red surge, handing out brand new $5 bills to all us good treaty Indians. The annuity payments. Hunting, fishing, and trapping rights were guaranteed to our people. The size of our reserves were guaranteed. But some of our reserves never got the right size of land, so that's why we have treaty land entitlement. That's why Saskatchewan got urban reserves, okay? Because of treaty. The little red brick schoolhouse at the house of the Indian agent. When you're ready to settle down on your reserves, we'll provide a little red brick schoolhouse and teach your children the cunning of the white man. And at the house of the Indian agent in Treaty 6, in times of pestilence and famine and sickness, we will make sure that there's medicines there. The medicine chest clause in Treaty 6. So all these treaty promises were in Alexander Morris's treaty book. Some are in the treaty itself, but they're in Alexander Morris's treaty book. Alexander Morris was the Queen's commissioner, the Crown's commissioner that came out. And he was saddled with the task to consecrate a nation-to-nation deal with Little Black Bear and Coacatoos. Okay? That's treaty right, but depth of a plow. Only this much. Then, the Indian Act, 1876, was formed. Why I put that there is because, and I didn't even go into residential schools, things like that, but two biggest things, just quickly, that have a negative impact on First Nations peoples in Canada was the residential school system, and that was cultural genocide, and the imposition of the Indian Act, which is basically control. From the womb to the tomb, the Indian Act controlled everything, and we still have it to this day. Why that's important, and I want to go to this slide here quickly, on the Indian Act, slide 11. There we go. This was in the Indian Act, right up until 1951. Basically said, if I went to you in 1950, if you're all lawyers now, you're all passed and you're all doing good things, you're lawyers. 1950, I'm a treaty Indian from Black Bear. In order to go visit you, I had to get a permit first from the Indian agent just to get off the res. That's a whole problem. That's a whole other story. But then if I go see you, it was illegal for me to get legal advice. You'd be thrown in jail and disbarred, and I'd be thrown in jail too for trying to seek legal advice for our claims. This was on the books till 1951. A treaty Indian, First Nations person could not have access to a lawyer till 1951. Then they finally changed that. Okay? That's huge. Because how can you start to make a basis, legal arguments for your rights? You didn't even have access to legal counsel. Right? Anyway, that was on the books. So back to the timeline. I wanted to show you that there. And 1905, province of Saskatchewan was formed. Wasn't part of Confederation. 1874, when Little Black Bear entered into treaty with the Crown, nation to nation, had Section 9124, the federal government's responsible for Indians and Indian lands. So we always have this debate. Well, who's responsible for Indians in Saskatchewan? Feds or the province? Offloading of treaty rights? Oh, that's been ongoing since the treaty was signed. 1961 through EPF financing, education, healthcare, social services went from the feds over to the provinces. So billions of dollars were transferred. Were those treaty obligations? Yes, they were. Are they transferred to the province? Yes, they are. Is that offloading? Yes, it is. Does that have impact on Section 9124? Yes, it does. Keep in mind interjurisdictional immunity. That's going to be a key word we're going to come back to later on. Feds, province. The Royal Commission on Aboriginal People recognized the federal crown, provincial crown, and First Nations governments as well. So, 1905, Saskatchewan being formed, there's always that jurisdiction. Who comes first? Who came first? The treaties, and the province was formed in 1905. Created, 1905. And then, 1930, Natural Resources Transfer Agreement. How many are familiar with that agreement? Any hands? 1, 2, 3, 4, 5, 6, 7, 8. Okay, we got a room of about 30 people, 8. I'm going to spend a little time on this thing. 1930 Natural Resources Transfer Agreement. The federal government unilaterally gave, in 1930, to the provinces of Manitoba, Saskatchewan, and Alberta, no consultation nor consent by Indians, First Nations people, but they just enacted this 1930. Because the provinces of Alberta, Saskatchewan, Manitoba were saying, we're not the same like the other provinces in Canada, like Ontario and Quebec and Nova Scotia, the ones out east. They can control all their lands and resources in their provincial boundaries. We want the same thing. So they put pressure on the Canadian government in the 1920s and resulted in this passing of this legislation in 1930. The Natural Resources Transfer Agreement, which basically said, okay, you three prairie provinces, you now control all your resource wealth in your provincial territories, provincial boundaries. Very important. It was done again. No consultation or consent from Indigenous peoples. It was passed subject to existing trusts. Number 12. I want to spend a little time on that one. This one. Section 1 of the NRTA. In order that the province may be in the same position as the original provinces, looking after all their interest royalties derived from province shall belong to the province, subject to any trusts. I wanted to put that in there. Federal fiduciary trust obligation to Indian people, Section 9124. So the NRTA was passed subject to existing trusts. So my position has been and always will be, they breached a trust. They breached a fiduciary trust obligation to us when they unilaterally passed that piece of legislation in 1930, when that big government gave to the little government. How can you figure these 85, 90-year-old men had it in their minds and their spirit to bring that up to me, and I was like 30 years old, sitting around a table on Kawakatus Reserve. That big government grandson, had no right to give to that little government. This much. And what's below this much? Think what's below this much in Saskatchewan. There's potash under there. There's oil, coal, and gas under there. Oh, there's uranium under there. There's even diamonds by PA, by James Smith under there. There's lots underneath that depth of a plow. Right? So, this is key. I threw this one in here, and I'm kind of jumping ahead a little bit, but this is a good point, because in the future, one of you might be helping out a chief and council at the reserve level, or a tribal council, or a regional chief, or a national chief, or somebody to say, hey, in Horseman, what did Corey say? He was talking about the NRTA when it was passed. Although it might well be politically and morally unacceptable in today's climate to take such a step as that settled in the NRTA agreement without consultation with and concurrence of the native people affected, nonetheless, the power of the federal government to unilaterally make such a modification is unquestioned and hasn't been challenged in this case. May not have been challenged in that case, but let me tell you, there's things percolating across this country where it may be challenged soon. So watch for that one. But I'm not doing anything about that. Anyway, back to the timeline. So, that's the NRTA. Why I've always called that unfinished treaty business. Unfinished treaty business. 1982, the Constitution Act. That was a big thing. Section 25 and 35. Existing Aboriginal treaty rights are recognized and affirmed. It's a big thing. Is it a full box of rights in Section 35 of Canada's Constitution, or an empty box? We believe it's a full box. But if we disagree with this government, and we do all the time, what process do we utilize to fill up Section 35? Is there a political process whereby we sit with the feds in the province to fill up Section 35? No, not really. Nothing with any kind of meaningful substance and authority and mandate. So it's been the Supreme Court of Canada, the judicial branch, to fill up Section 35. And it's a slow process. We've had this since 1982, Section 25 and 35. We still have the debate amongst Indian people. We have the debate, and this is the debate. In 1980-81, there's a group of Indians, Treaty Indian people, lobbying the elected leaders to say, don't put Section 35 in Canada's Constitution. You're domesticating our international treaties. You're hurting our international treaties. You're hurting our sovereignty and our nationhood as Indigenous peoples. Don't put Section 35 in there. Because you're weakening our international treaties, nation to nation. That's still a debate we have. Then on the other side, if you didn't put Section 35 in there in 1982, do you think we would have won Chilcotin? Do you think we would have won Siwi, Sparrow, Buren, all these Supreme Court decisions? No. Wouldn't have happened. So, double-edged sword? Double-edged sword. Even to the simple thing, and I know I digress, but a simple thing like voting. Should Indians vote in federal white man elections or provincial white man elections? That's still a debate we have. Because we weren't given the right to vote till 1961. Indians couldn't vote up until 1961. Had no right to vote. Weren't recognized as citizens of the country. Weren't recognized as people. But in 1961, Deef the Chief, no pun intended there, granted and gave the right to vote for all Indian people in Canada. Made the decree, made it law, And so since 1961, we've been having, like, the old people will say, no, don't vote, that's Munya, that's theirs. We have ours. We don't care who gets in over there. We have a treaty with the Crown. They're supposed to live by it and abide by it. But then on the other side, if you're a member of Parliament and you're running, and Indians don't vote for you, are you going to care about their issues? Are you going to care about their concerns? You don't help get elected. They don't vote for us. So it's a double-edged sword, eh? Another double-edged sword. It can hurt you, but it can help you. So you got a federal election coming up October 19th next year. You got a lot of First Nations people running for the Liberals. You got a lot of First Nations people running for the NDP because the individual right now. And someone told you that, but it's like the individual rights supersede the collective rights. That's what's happening. So when people ask me, well, what do you think, Bellegarde? Do you think Indians should vote? Well, I say, yeah, it's an individual thing. It's an individual right. Get concept with a concept called dual citizenship. Get comfortable as an Indigenous person, as a First Nations person, with a concept called dual citizenship. Because you're a dual citizen. I'll always be a member of Little Black Bear. And I'll always be Cree. Speak Cree. I'm going to be a part of that. But I'm also a citizen of Saskatchewan, a citizen of Canada. So if I choose, who can stop me? So it's a dual citizenship. And I think if you're going to have a push for sovereignty and nationhood, which is going to be ongoing anyway, keep doing that. You still need to get involved where decisions are made. You have to get involved. So I would say I want to see a lot more First Nations people involved where decisions are made. And that's around the cabinet table. I want to see more First Nations people involved around where decisions are made in the corporate world. That's around the board table. That's CEOs, the management teams. That's Chancellor of the University of Saskatchewan, Blaine Faithful. It's starting to see more and more First Nations people rising up into positions where decisions are made. And that's a good thing. Now, back to the timeline. Now, so Section 25 and 35. They're still in Canada's Constitution. Everything I talked about are in some way, part of Canada's Constitution. So when I get up and say, we want to look at resource revenue sharing, it's because of the depth of a plow. It's because of all these things I just outlined. So to me, there's a historical timeline, there's a history, there's a legal requirement, there's a social requirement, there's a humanitarian requirement. If you want an economic or an economy that's stable, you need to involve First Nations people. Not only because it's good for the economy, it's also a legal requirement. That's the case that I always put forward. So now on all these other ones, the Algamuk was a big thing. Aboriginal title exists. The Algamuk ruling. Elders' oral history and testimony is admissible. Very important case. Haida and Taku, Honor of the Crown, duty to consult and accommodate. All parts of those things in there. Mikisew Cree. This was important. Taku River was the first one in BC. And then Mikisew Cree came afterwards. That's important because everybody thinks, there's no treaties in British Columbia. There's Aboriginal rights and title. Yes and no. They do have treaties in BC. But Taku River was the first one. And then the Mikisew Cree from Treaty 8 came later. But the principles are still applied. You got to consult, accommodate. You got to involve First Nations people. I always say, with 204, 205, those Supreme Court decisions, we've used duty to consult and accommodate. We always use those words. UN Declaration, free, prior, informed consent. Okay? I like using FPIC, free, prior, informed consent. And that comes from the UN Declaration. That's very important for us. I always put these last two bullets on because the relationship in Canada really is unnecessarily adversarial. To the point where the government spent $106 million last year in litigation. $106 million to fight treaty rights, inherent rights, to suppress fundamental human rights, if you look at international law. And it doesn't have to be that way. Does not have to be that way. The United Nations Special Rapporteur on the Rights of Indigenous Peoples, James Anaya, pointed that out in his report. In a rich country like Canada, the issue really is poverty when it comes to Indigenous peoples. Marginalization from the economy. It really comes to, and he pointed out, overcrowded housing. He pointed out high suicides amongst our young people. And he went on to say the relationship with the government is so unnecessarily adversarial. And that's what's got to change. So, I always say 6th versus 63rd. Canada is rated 6th in terms of the United Nations Human Quality of Life Index. You apply those same indices to Indigenous peoples, we're 63rd down here. And that's what's got to close. That's what has to close. And so, I'm depending on people like you here in this room and others across this land to get behind concepts like resource revenue sharing, getting Indigenous peoples involved in the economy because it's important. Now, I've got 5 minutes and I'm trying to wrap up. I've got to go quickly now. I've been going quickly right through 15. Because I want to leave some comments for time for questions and comments. Okay. Chilcotin and Keewatin. And then we're going to close off here. So Chilcotin was important for us, and we celebrated. I was there with Roger William when he came across Saskatchewan on his way to Ottawa with his elders and his youth people in Regina. And we also hosted them on the way back after they presented when we heard the Supreme Court of Canada arguments. And we were so happy. But there was a different energy around that case. Like when I say there was a different energy around Chilcotin and William case versus the Keewatin case. There was a different kind of energy. There's a different kind of planning. There's a different kind of organizing. There's a different kind of vibe between the two Supreme Court cases. And one, on this one, on the Chilcotin case, I would say there's a spiritual aspect to it, very strong spiritual aspect. And just being part of it, I could say I witnessed that. And it's an important decision because, where was it? I wanted to make that point. The postage stamp piece. That Aboriginal title is recognized and affirmed. And that it's not limited to just, you guys fished off that rock, so you got Aboriginal title there. Or you had four houses, 4 little teepees over here, that's your Aboriginal title. It extends beyond that. It's in their ancestral territories, their traditional territories. And so it goes beyond the little postage stamp. That's a game changer. It was 8-0. 8 Supreme Court Canada judges. And that's important. So how do you recognize Aboriginal rights and title when you want to create economic certainty in the provinces? The other points, Aboriginal title is a unique and beneficial interest in the land. It's a right to use and control the land, to reap the benefits from it. And this is In the absence of consent, the Crown, including notably provincial governments, may infringe the rights of Aboriginal title holders if the test for justifiable infringement is met and the Crown meets its fiduciary obligations. So, these are the points from the William case, Chilcotin case, Chief Roger William. And we lift them up. And this is an example where I tell other Indian people, First Nations people across Canada, when one of our First Nations, no matter who or what it is or where they come from, we've got to support them. Because if they win, we all win. So from our FSIN, we helped intervene with the Chilcotin people. We provided legal, political, elder support, whatever we could. So we can say we're part of that in a small way. That makes me feel good. Because in Taku River and Mikisew Cree, we weren't. People go off and let them fight on their own. So the whole point for us is we've got to work together collectively. We've got to keep that strong legal strategy going forward in a good way. Now, 1 week we celebrated the Aboriginal rights and title in the Chilcotin, the William case. A couple of weeks later, Keewatin came down. And I was really in a quandary with this one. So on one hand, I'm celebrating, wow, we won in the white man court, in their court. And then when Keewatin came down from Treaty 3, the whole issue was, who's got the right to issue licenses and permits to industry? Feds or the province? Treaty 3 was arguing, hey, the feds have a role to play. Remember Section 9124, the Crown relationship? Well, in Keewatin, they said, nope, provincial governments can issue licenses and permits. Right? And so it was offloading of a federal government fiduciary obligation to the province. So it kind of hurt us. In a way. That was my interpretation. But I tried to put a positive spin on it. So I said, wow. It's not hard to figure out if you take our international treaties into white man domestic court. Do you think we're going to get justice? That was my press headline. So on one hand, I recognize that white man court over here with Chilcotin, but then over here, I don't really want to recognize it too much. So it's just a quandary a little bit. But I'm saying because that, again, anytime we go into the Supreme Court system, if you will, I wish I could appoint the Supreme Court judges. I want to see more First Nations people there, or people that have a good grounding in inherent rights and treaty rights, that are going to be making determination decisions on these very important cases going forward in the future. But that's not the process. Who gets to appoint the Supreme Court judges? You all know that. Federal government. But Prime Minister Harper tried to put a few people in from Quebec. That got challenged. So I think the Supreme Court Justice and the Supreme Court kind of was sending a message. I think she sent a strong message. Don't fool around with the impartiality of the justice system here. You executive branch of government. Judicial branch is one branch of government. You have legislative, executive, judicial branches of government. Try to keep them separate. Don't overlap. I think there was a strong message sent. So Treaty 3, that was there with Keewatin. Last slides, I wanted to just put why I think Canada kind of failed. In a way, there was an opportunity. This is where I'm trying to bring in the international elements about international law, human rights, and utilizing the UN Declaration. I think as we move forward in Canada as a nation state, you've got to start looking at the international law component, the international law piece. And when I say these points here, courts and governments in Canada will find themselves engaging with us on how to reconcile the domestic law of Aboriginal treaty rights with our First Nations perspective on our inherent and treaty rights as well as international law. And there's a lot of issues to work out. Tons of issues to work out. In Saskatchewan, again, when we push for resource revenue sharing, I always tell people and challenge people, it's a good thing. Get comfortable with that. Just think how stronger the economy would be if First Nations people are involved in a meaningful, substantive way. Not only for the jobs and the economic wealth it'll create, but respecting the environment. Making sure that there's a sustainable strategy going forward that respects the land and the water. That there's a balance there. Because we also have common law and civil law, but you also have creators law. There is First Nations law. And it's something we all have to figure out how it all works together. It's not just two systems. I always say Canada wasn't just founded on French and English, the two founding nations. There are indigenous nations here. But it's all about how do we work together, how do we get along, peaceful coexistence and mutual respect. It's not domination and civilization and assimilation and termination of anybody's rights. It's about working together and getting along, but respecting the different jurisdictions. And there's lots to learn from the international law aspect of our treaties. And there's lots to learn about the path toward economic certainty. It lies in this legal environment built on mutual respect and true sharing. That's how we're going to build revenue sharing in Saskatchewan. And that's how we're going to make sure that there's economic certainty when K plus S or BHP or anybody else wants to come and develop the natural resource wealth to involve First Nations people. It's a good thing. And so that's what I'm asking of you students here as you're going forward. Don't be afraid to challenge the existing. Embrace change because it's good. Urban reserves are good. Self-determination is good for Indigenous peoples. Treaty implementation is good. Resource revenue sharing is a good thing for all of us. Because our kids are going to have a bright future, and that 6 versus 63rd is going to close. Okay? Ipse, I'm done. You got time for questions, and you can leave with 8 minutes to go. That's it.